Thank you for this invitation. It's wonderful to be here with you. And it's phenomenal as it relates to the understanding and the appreciation as it relates to linguistic issues in the court system and across the entire United States. I do want to tell you that if you do remain, that at the end I will give each of you a copy of the Constitution. And you can remain silent if you wish, and then each of you an American flag that's magnetic for your benefit. And Rebecca Horn, who is my law clerk, is here, and she'll be dealing with the PowerPoints. It was over 61 years ago that I gave my first speech, public speech, and I don't know what possessed a 10-year-old boy to speak on the Dead Sea Scrolls. That was such a didactic subject, and I was nervous and flustered, and I announced that I would be speaking on the Dead Sea Squirrels. Now, my brother and friends were on the front row, and they were so delighted, and I'm not sure that I have fully recovered from that experience. I do admit that I'm one of the most senior judges on the bench in the state of Utah, and I usually say I'm the most seasoned judge on the bench for the state of Utah. I frequently speak to youth groups and often about the Constitution, and I'm forced to dispel one of their myths. Regardless of their impressions, I personally confirmed to them that I was not present in Philadelphia in 1787 for the signing of the Constitution. Now, just to get to know you better, how many of you we're talking about limited English proficiency, individuals, etc. How many of you speak foreign languages? So probably about half of you. What languages do you speak? Just very, very quickly. Spanish. Swahili. Okay. Okay. German. Okay. Okay. Wow. That's pretty impressive as a group here of linguists, and we have attorneys, and we have some judges and others here. That's pretty remarkable within our community. Are there two of you that don't speak any Spanish at all? Anybody that doesn't speak Spanish? Okay. Well, let's see. I need a couple of volunteers to come on up. You'll be one of them. And let's see, who else doesn't speak any Spanish at all?
Sure, Jarvis.
Oh, yeah, Scott Jarvis. Okay. So, Scott, if you both of you will just stand in front of me here, just for a moment, and be right here. You can just sort of look at each other here and sort of look out there. Okay, let's start this off, just as an example. Ustedes están frente a sus amigos para ser unidos en matrimonio bajo las leyes de este estado. Es institución la que guarda la fundación de nuestra sociedad y ha sido pasada para promover la seguridad y la felicidad para ustedes y su familia. El propósito de esta ceremonia es para darles cada uno de ustedes la oportunidad de declarar públicamente sus sentimientos a uno a otro. Primeramente, Scott, excepto tú, Jennifer, para ser tu esposa legalmente. Y tenerla y armarla. Okay, so I think we've got it. Por virtud y la autoridad investigada en mí por las leyes del Estado de Utah, yo los declaro ustedes marido y mujer. You can be seated. Okay. You can. Thank you. Well, that's sort of an attention-getting activity as it relates to that. But if we interpret it further, frankly, the fact of the matter is that within our court systems, if you don't understand the language whatsoever, you're clueless as it relates to the constitutional principles and a variety of things that way. Now, that was not a legally binding ceremony. I wanted this just a ruse, but I think you all understand what was going on. And it's a shame, too, because it was such a lovely wedding and a wonderful location. But this is what happens or can happen every single day. Now, I want to share an experience that my wife and I had and some years ago. And that was, I think I've got it here somewhere. I think it was about 2008. I will, here somewhere. Well, let me just give some other examples before I get to that. As most of you're aware, the United States has been called a melting pot. And that concept was first introduced back in 1782. And then it was popularized by an individual by the name of Israel Zangwill in 1908 in his play that had the same name. In his letters from the American farmer, Crevaseur celebrated the mixture of 6 or 7 predominantly European nations melding together to form a new race, the Americans. And he hardly could have imagined the expansion of that in the crucible today. When the first U.S. Census took place in 1790, we had 3.9 million people. The largest ethnic group was English, although nearly 1 in 5 were African Americans descent, despicably enslaved. By contrast, in 2010, our last national census, it was advertised in 28 different languages and counted almost 309 million people, of which 7.8% were considered ethnically English, and 12.3% were African American. Immigrants from every nation in the world have contributed to our ethnic, cultural, and linguistic diversity, and we are proud of that. In California alone, there are now more than 200 languages and dialects. That's incredible. 14 million residents, 40%, speak a non-English language at home, and nearly 7 million have English language limitations. 7 million within one state. At critical moments in our citizens' lives, those with limited English proficiency are struggling to communicate and to understand. And our diversity is one of our greatest assets, but it also presents significant challenges that we are all aware of. And we must thoughtfully consider as we take the opportunity as a group and as a nation to design, test, and refine effective solutions for our people. They are our neighbors, they are our friends. Qualified and accurate interpretation and translation services are essential in providing meaningful access to justice. Now, the right to equal justice and due process that we enjoy in our country was in fact emphasized to me back in 2008 when I had a startling experience with my family in a country that was formerly part of the Soviet bloc. We were in the airport just about to board a plane bound for America, and suddenly uniformed officers surrounded me and took me into a small room in the airport. They separated and divorced me from my family and would not allow my son, who spoke their language, to accompany me at all. In that small windowless interrogation room, they confronted me loudly and searched my luggage. They accused me of stealing national treasures and verbally attacked me in a most demeaning and very, very threatening manner. I was scared to death. I was afraid for my life and the safety of my family. That claim, of course, was absolutely outrageous. It was baseless. It was absurd. But just when I thought they were about to physically attack me or to imprison me, I raised my voice and told them confidently that I was an American judge, that I knew something of international law and treaties, and that I had no idea what they were talking about. Their threats immediately stopped, and they sincerely apologized. I was promptly released, and they invited me to rejoin my family and allowed us to board the flight. They actually extended their hand out and shook my hand and welcomed me to the country. That was very interesting to me as sort of an afterthought. This incident deeply reaffirmed my devotion to the fundamental principles of the rule of law embedded in our Constitution, and confirmed to me the absolute necessity of providing equal access at all stages, especially for limited English proficiency individuals in our country. If they can't understand what's happening, why are they being detained? They don't know how to fill out the forms, how to find their way around the courthouse. There's no meaningful or fair access to justice for them. They face language barriers every day in attempting to access rights and the rights of courts, and how to assert those rights, those constitutional mandated rights, and to remove those barriers and address their needs. And most of you are involved in some fashion as it relates to that. Now, here in the state of Utah, the Utah State Court's mission is, quote, to provide an open, fair, efficient, and independent system for the advancement of justice under the law. And likely all courts have similar motives and purposes and statements across this country, but no court can be open and fair without providing critical language services to LEP individuals, that open access to all of the many judicial services available. Without meaningful language access, participants who speak limited English are effectively denied access to the very laws created to, in fact, to protect them. And particularly in high-volume courtrooms where the majority of litigants are self-represented, and that's often in family law, small claims, traffic court, et cetera, or where understanding the questioning is essential, such as justice, criminal, and immigration court. LEP individuals face significant challenges that cannot be overcome without appropriate language assistance. Now, with that, I will mention to Janet that of all of the hundreds of cases that she reviewed, none of them were mine. I just wanted you to know that. But in criminal proceedings, the Constitution entitles defendants to the assistance of the interpreter under the Fifth Amendment, the Sixth Amendment, the 14th Amendment. In civil matters, the Department of Justice is found under Title VI of the 1964 Civil Rights Act to be controlling. Language-based discrimination is a form of national origin discrimination under Title VI and is strictly prohibited. We finished let's see, the week before last, a multi-day civil case before a jury in the Spanish language. He was entitled to that. He did not speak English, and he was entitled to have court interpreters. We had probably somewhere in the neighborhood of 4 to 6 interpreters there daily, and working with him very, very closely. Now, state courts throughout the country have renewed their focus on language access planning and services for the LEP individuals, largely in response to the rapidly growing LEP populations. Those that did not were reminded under Title VI of their obligation by the Department of Justice in 2010. When it began cracking down on the reluctant jurisdictions. And also in response to these queries regarding what to change and how to implement those changes, the ABA released a comprehensive language access report. Of course, the National Center for State Courts published its national call to action in 2013, both of which suggested concrete actions that courts could take to improve as it related to language access. Now, so we've made an awful lot of progress in my estimation. Let's go to a circumstance in the state of California. It's cold, and Jorge is standing with his mother outside the immigration court building in Los Angeles. They have been there for the last hour, shivering in the cold winter air. The immigration courts are supposed to be resolving immigration cases, but they are slowed by the lack of access to qualified interpreters. And federal law requires that the courts provide interpreters for immigration hearings for LEP individuals. Some courts have staff members on hand who speak Spanish or another of the more common language. But more and more immigrants have been coming from countries that speak uncommon languages, such as Quiche, which is spoken by Mayans. Because there are so few interpreters, they are hard to find. Courts have resorted to, of course, video remote interpretation or phone interpretation, but the connections are often slow and choppy. And some experts estimate that only 50% of the proceedings are being interpreted. If an interpreter doesn't speak the right dialect or a quality connection, it's not available. The hearing must be rescheduled, which can result in individuals being detained far too long. Logistically, finding an efficient and effective solution for LEP user is a challenge, and the court must find an interpreter for that individual's unique language or dialect. We have to. Judges, in my estimation, are gatekeepers, and they must be, as it relates to limited English proficiency individuals. And we must make sure that standards are applied, skills to interpret the legal proceedings are there. Lately, there has been a sharp increase in the number of defendants who speak indigenous languages. For example, in Oregon, a demand for interpretation of indigenous languages, such as MOM, increased by 42% from 2015 to 2016. But only one interpreter in the estate spoke that language. In the immigration courts last year, Quiche was the 12th most common spoken language, right behind French. Well, there are only a few dozen qualified Quiche interpreters in the entire United States, and a recognition as it relates to that. Court interpreting is especially tiring because of the highly technical and specialized language used and the rapid-fire questioning from attorneys, which often requires interpreters to work in tag teams in order to fight fatigue and to ensure that they are proceeding accurately. We cannot allow the heartbreak and the injustice of a child trying to translate for his or her parents in family court, or a tenant relying on his landlord to explain what a judge is saying during an eviction hearing. When used appropriately, remote video interpretation has the potential to increase access to certified interpreters, even those for obscure languages and remote courts. But we have to make sure that we are following through in connection with that. Now, the last time I had a major LEP case, I haven't had one since yesterday, and two defendants that appeared before me spoke solely Romanian, and we had to secure a court interpreter who came down from Salt Lake City to where we are, about 45 miles south. Spent time with them. He spoke excellent Romanian. One of the very first things that a judge does under those circumstances is to administer the oath to that individual and make sure that the attorneys and others and also the accused understand and can appreciate the role of the interpreter. But it went extremely well, and it was well understood. And one of the defendants had a sister and a brother-in-law in the back of the courtroom. And at the end, they were very grateful and bowed to us and thanked me in that motion as a judge in connection with that. Now, but scheduling can, in fact, be very, very, very challenging. Even in that case yesterday, we summoned the Romanian court interpreter at a very early stage. The attorney came, and then he had to go to another court, and then was not there at the time that the case was, in fact, called. And then we didn't have an interpreter for the two individuals, and we simply indicated that we would have to wait. Well, we had the interpreter, but we didn't have the attorney. So we'd have to wait until that attorney returned. Well, then we had to call that attorney and had to text that attorney and get him back as quickly as possible and get him to meet with the accused and go through that entire process and have the benefit of the interpreter. Wow, so there are days that become complicated as we are attempting due process and as we are attempting in every way possible to protect the constitutional rights of the accused. Days are not simple for us. Now, as I've indicated, scheduling can be very. Now we have technology challenges. We have budgeting challenges across the country as it relates to providing for LEP individuals. Most states have a small staff of overworked interpreters and use freelance interpreters, et cetera. So we've got in technology, in immigration courts, and a variety of other places that way. Now, I'm going to go to page 10 here, because in New Mexico, more than a third of the residents speak a language other than English at home, twice the national rate. More often than not, interpreters are required for every proceeding. New Mexico is also the only state that explicitly allows non-English speaking citizens to sit on juries. Maybe the only state in the nation. The interpreters must also be provided for the jurors, not just the witnesses or the defendants. The state has been granting emergency funds, but costs continue to outpace what is available to the court system. In Texas, counties are responsible for providing local court budgets. However, state law requires certification of all court interpreters. But although the need is high, in 2012 there were only 141 certified court interpreters in the entire state of Texas. A scarcity of qualified court interpreters combined with surging demand results in much higher costs. In Lubbock, Texas, it saw interpreter costs triple year over year. In one trial, the need for multiple interpreters dramatically increased the length of the trial and also the costs involved. The defendant and several witnesses were either deaf or hard of hearing, required ASL interpreters, and I'm very congratulatory and thankful for all that is occurring here, and we have numerous cases within the state of Utah in terms of ASL. Anyway, there was, in one case, they had to bring interpreters from Austin, several hundred miles away, because there weren't any available in the Lubbock area. The expenses increased, incredibly rising, and the budgets could not meet that. Now, next, in terms of certification for the more commonly spoken languages, the problem may not be in finding an interpreter, but a certified interpreter, and there's a level as it relates to that in every single state. In the state of Utah, we have a declaration. We have an approved interpreter, a certified interpreter, and a conditionally approved interpreter. And we have a language access committee, and you have something comparable to that in every state of the union. But we work together in terms of skills, and beyond being technically competent, language service providers must also be ethical, adhere to a professional code of conduct, And in certain situations, asking or expecting an interpreter to, quote, help can introduce reversible bias or error. A common mistake is when the court or an LEP individual asks the interpreter to explain a term. Well, interpreters don't explain terms. They simply have an obligation and responsibility as it relates to interpret what is being said. They must not interject bias or engage in legal advice by attempting to explain terminology in other words. So it's critical that we expand our access, beyond the courtroom, and we have obligations and responsibilities as judges and also as attorneys in the courtroom to respect the fact that interpreters have canons that they must live by and have to live by professionally. I wanted to point out, and I'm going to jump down to the bottom of page 12. In the last year alone, out of 36 responding states, $220 million was spent on court interpreters. 42 states have a language access plan. 6 states are in the process of developing that. 2 states are updating their plans, and only Louisiana and Mississippi have yet to develop a language access plan to provide LEP individuals with meaningful court access. And if there's a place you need interpreters, it would be the South, in my estimation, in terms of language. I remember years ago having a wonderful, wonderful lady from the South in our courtroom, and she was speaking, and she was making reference as it related to one of her children, and she said, if I can quote her correctly, you have a squirrel in the tree. Well, I'm trying to figure out how, if there were an interpreter involved, how would they know that? A squirrel in the tree, as you're looking at someone, means you have a booger in your nose. Now, nobody would ever know that, and how do you ever translate those types of things in terms of local types of things? Like Janet, we don't have 2,500 cases involved as it relates to this, but I did have my law clerks take a look and try to make a determination for the last 5 years how many cases across the entire United States dealt with the issue in connection with court interpreters. There were somewhere between about 250 and 300 cases. No, there were more than that. She's got her thumb up here. So there may have been 300 to 400 cases. There may have almost been 500 cases across the United States. So I thought I would go through each one of those. But I want to highlight some of the cases. To prevail on a translation-based due process claim, the allegations of translation difficulties are not enough. Much of what has been indicated here. The petitioner must show that a more proficient or more accurate interpretation would likely have made a dispositive difference in the outcome of the proceedings. Now, let me cite just a half a dozen cases. Matias versus Sessions, and that's in the First Circuit, and that was 2017. To prevail on a translation-based due process claim, the allegations of translation difficulties are not enough. The petitioner must show that a more proficient or more accurate interpretation would have, in fact, likely have reached a different disposition. United States versus Henry, the Second Circuit in 2018. A defendant's right to waive the use of an interpreter is not absolute, and a defendant's waiver request need not be honored when the court finds a compelling reason to deny it. A defendant has a qualified right to waive the use of an interpreter, but the district court has discretion to determine whether waiver is reasonable under the circumstances presented. Now, in connection with that, I will indicate to you that I had a major first-degree murder case. The accused was Hispanic, but he had graduated from college, from USC, and spoke excellent English. He was able, of course, to communicate with his lawyers and with witnesses, with everyone. Nevertheless, because of the nature of the charge, which was a first-degree murder and also desecration of a dead human body and some other charges, I made the decision that we would have court interpreters there for every hearing, for every day of the jury. And that if there was at any stage that he did not comprehend a legal phrase or anything else, then he'd have the benefit of that interpreter being there. So the interpreters remained during the entire time. They were consulted very, very infrequently, maybe once every few days in connection with that. But that was a decision that I made, and I would make it again as it relates to the nature of the charges, and to preserve rights on appeal or a variety of other things that way, and to give him, the accused, the absolute benefit under those circumstances if there was anything that was unclear, any word or phrase, to consult. Now, here's another couple of cases. Mendoza versus the U.S. It's the Seventh Circuit. A defendant has a Sixth Amendment right to communicate with counsel. He has a due process right to an interpreter to help him understand what is said at trial and to communicate with counsel. However, he does not have a due process right to have an interpreter continuously seated at the defense table. Defense counsel was not ineffective for failing to object to the trial court's decision to move one of the Spanish-speaking defendants to interpreters near the witness stand to interpret for a Spanish-speaking witness, where another interpreter was at the defense table and available to the defendant for communication with counsel. And I would agree with that as it relates to that decision. Lastly, well, let's see. We do have, and I've got them from Connecticut to Colorado, Delaware, Florida, Georgia, Hawaii, Illinois, Kansas, and I think actually from Utah, and Texas and Utah. In interstate cases, a 2018 case, the Court of Appeals upheld the denial of defendant's motion to withdraw his guilty plea, finding that the district court did not abuse its discretion in denying the motion, largely because of appropriate language assistance. There was a competent and qualified interpreter appointed for the plea colloquy, although the defendant appeared to speak and understand English. The defense attorney had a qualified interpreter present at every interaction where the attorney discussed the case and any legal issues and consequences with the defendant outside of the court. A different certified interpreter was present at the evidentiary hearing where the defendant asked to withdraw his plea. Despite defendant's claims of inaccurate translations, there was no specific instances given of any inaccuracies of translation that influenced the defendant's decision to plead guilty. So that was a 2018 case here. Now, I want to make some judicial observations. And as I've indicated to you, that judges, in my estimation, must be the gatekeepers. And often they are not. Here's some observations. I printed them out. They're going to be in the back for you. But in the courtroom, interpreters can only interpret the language, not the meaning. If the defendant does not know what the word means, the interpreter must ask the judge or attorneys to define or rephrase what that meaning is. Judges should not ask the interpreter to make exceptions. If videos or audios are produced as part of the trial, make sure that there's a transcript given to the interpreters ahead of time, especially if the audio quality is poor. And that is often the case, whether it goes back to Miranda or wherever else it may be. Almost all of the Miranda cases that we have are audio, so we do have the benefit of that. Now, we ought to allow interpreters time before the trial to view the documents that will be used or referred to in the trial, even if someone is going to cross or introduce the documents, especially if it would be in detail. And that can involve police reports. It can be written statements. Context makes a great difference, a lot of difference in translation. It impacts the integrity of the entire trial. We ought to, as a court system, set up all of our translation equipment in advance and train the clerks as it relates to that process. One of the, and attorneys that are here ought to be aware of this. After the last jury trial a couple of weeks ago, I sat down with three of the interpreters that were involved, and I asked them questions. And they said, and I said, how are other jurisdictions doing? What's happening in connection with this, et cetera? And they said, in some jurisdictions, the judge who is calling the case and has the attorney and the accused at the podium will call the case and not acknowledge the interpreter and continues as it relates to the case as the interpreter is racing up to the podium. That can't be done and has to be modified in my estimation. Under certain circumstances, we can have counsel wear a lapel microphone, allow interpreters to move around the courtroom in order to hear what is being said. We ought to caution bilingual counsel at the outset that they should allow the interpreter to do their job and not disregard the appointed interpreter. If they are worried something is not being interpreted correctly, they may ask for a short break to address the issue outside the presence of the court. They should not attempt to interpret the proceedings if a certified court interpreter is available or the integrity of the proceedings could be, in fact, compromised. And I see that from time to time when counsel, particularly those that speak Spanish, they'll have a court interpreter right there, a certified court interpreter, and I'll see counsel and the accused speaking back and forth in Spanish, and I don't have a clue whether or not there's been an interpretation of what the judge is saying as it relates to the legal colloquy. So that's something that ought to be looked at. We ought to thank interpreters at the end of proceeding. They have just run a mental marathon and may be both physically and mentally exhausted. Thank you is appropriate and rewarding, and I would invite judges to do that. We ought to be, of course, appointing a qualified court interpreter at the very earliest stages. If there are multiple defendants, of course, we have to. There may be some conflicts, and we have to have separate interpreters where possible. Attorneys should know and understand that Utah recognizes 3 levels of interpreters, as I've indicated earlier. Approved interpreters, a person who has been rated as quote-unquote superior and fulfilled the requirements of paragraph 3 of Rule 3-306 of the Code of Judicial Administration. We have a certified interpreter, a person who has successfully passed the examination of the Consortium for Language Access to the Courts fulfill the requirements of that same rule, and conditionally approved interpreters, and occasionally that happens. A person who, in the opinion of the appointing authority, after evaluating the totality of the circumstances, has language skills, knowledge of interpreting techniques, and familiarity with interpreting sufficient to interpret the legal proceedings, must be read and bound by the Code of Professional Responsibility and take the oath of affirmation. So, and just a few more that I want to address. In a criminal case, discuss with counsel appropriate voir dire questions addressing potential juror bias, especially racial prejudice and language bias, if any. Would it be distracting to any juror? Do they speak the language of the accused? If the trial is lengthy, or a jury trial arranged for multiple interpreters, it is exhausting. At the beginning of any procedure, identify the interpreter by name, level of qualification, and the subject language. Administer the oath on the record, as I've already indicated. I think that's particularly in front of a jury or others, to know exactly the role, the professional role that is played by the court interpreter. Interpreters can only interpret one person at a time. If multiple people speak at the same time, it impacts the accuracy and completeness of the interpretation. And it's the judge that must caution everyone at the beginning not to speak over each other, and then monitor the proceedings and make sure participants speak in turn and not simultaneously. Now that is a major problem in the courtroom, where we have two attorneys. You have the attorneys on both sides, and you have the judge, and you have a witness, and you'll have one attorney speaking, and another attorney will break in, and then I'm trying to rule, and we've got an interpreter, and they just say, time out. We can't do this at all. But again, it is the judge that must address that as it relates to the simultaneous speaking. Be sensitive to speed. A steady pace is easier to translate than very fast speech. Lengthy replies and quick statements will be much harder to interpret faithfully. Be sensitive to interpreter fatigue. Judges must be. And give breaks. Call more recesses in cases where interpreters are used, and encourage and respect interpreter requests for breaks. Now, as you have witnessed here, we've had some changes back and forth as it relates to the interpreting and the work that they're doing. And that benefits all parties, in my estimation. Now, just a couple of other things. Judges should never tell an interpreter, quote unquote, don't translate this. They are professionally and ethically obligated to interpret everything that is said. I know of one judge who indicated, now I'm ordering you not to translate this. Well, the Spanish interpreter interpreted exactly what the judge had just told him. And then he said, now, maybe you didn't understand. Well, and then he interpreted, maybe you didn't understand, and on and on and on. But they have canons of ethics, and we all must appreciate that, understand that, and recognize that they are bound by those canons of ethics. Fortunately, in the state of Utah, and hopefully in most other states, we have new judge orientation that we have every 6 months or once a year, depending on how many new judges we have. And part of that teaching does involve the whole concept of court interpreters, and can really, really appreciate that. And nationally, I hope that's being done. Instruct participants to answer audibly. Nonverbal responses are impossible to interpret. You can't interpret a head shake and bowing and those types of things. That just doesn't happen. And if needed, provide uniformly approved translation documents to the participants, such as affidavits of indigency and statements in advance of plea. And request and participate in language access sessions, of course, at any time that may come up in the judiciary. We need to teach judges across the country and in our individual states the deep appreciation they must have for the wonderful professional role of court interpreters. I'm hoping that that's being done. There's been a fair amount of publications, et cetera, across the country. Well, it's an honor to be a judge. You know, I mentioned to you, like yesterday I had about 80 felony cases, and someone said, well, how do you manage under those circumstances? Well, as a judge, I continue to say that I have great hope for change. And that if I didn't have that, I would not be a judge. Now, I reflect upon an individual that years ago was before me, and it was a minor misdemeanor case, but he came to court, and he was convicted, but he liked what he saw, and he really, really enjoyed that. He then went to college. He decided that with that, he was going to go to law school. He did go to law school. He graduated number one in his class. And the last time that I visited with him was back at the U.S. Supreme Court, back in Chambers, of the justice that he was then serving. So there are some remarkable changes and remarkable things that occur. Even though there are very tough times. Now, lastly, I would say to you, I want to thank you for your patience, particularly as you look up here. And, well, I'll tell you this little story. That so I was performing a wedding not too long ago, and a little guy, he was about 5 years old, and he's all dressed, and he looked sharp and everything, and he looked up at me, and he said, "What happened to your hair?" And I said, "I lost it." And he said, "Go find it. Go find it." So there are days that, that we have those types of experiences also as judges. But I do appreciate the interpreters that we have in this state. And I meet with them. And as I indicated to you, after jury trials, I sit down with them and ask them what we can be doing better. And how can we improve? What are some other states doing that you may have contact with that would make our system even better? I will tell you, when I did get appointed to the bench some 32 years ago, we didn't have any court interpreters. Most jurisdictions did not. And at that, formally, that had been trained and everything else that way. So that's when I said, well, who interprets for you? And they said, well, we just try to find somebody in the building, and if we have to go next door to another state office or this or that, then we'll go there and we'll do that. And I said, how do you know that they understand and comprehend as it relates to, well, we just hope they do, and frankly, then I saw a circumstance where another judge had called someone to interpret for him. It happened to be a law enforcement officer. Now, I can't think of any circumstance that could be more contrasting under those circumstances. And it was at that stage that I got an interest in equal access to the court for linguistic minorities in our community. And I'm very grateful to have made some of those changes and to work across the United States in connection with that. Now, as I mentioned to you, since no one's stood up and left, I will, oh, there's one other thing. If you do come up and you want a flag and you want a pocket-sized copy of the Constitution, I'll shake hands with you. And it'll be a sense of history that we will share. Because in late fall of last year, I spoke at the Lincoln Memorial University back in Tennessee. And after I would have brought a lot of Lincoln memorabilia and everything else, and some of you that have been back in my chambers know what I have there. But they let me into the museum back there, and then I was able to handle a lot of original letters of Lincoln. One that was written the day after the Gettysburg Address. So that was just wonderful. And in terms of a sense of history, I will advise you that I have not washed my hands since the end of October.